Thank you for joining us. This PowerPoint presentation and accompanying narration was created for East Texas Baptist University, course number Criminal Justice 1311 Fundamentals of Criminal Law, and I'm Dr. Eric Hillman. This presentation is based on the textbook Criminal Law, 12th edition by Joel Samaha. It is hoped that the students will watch the presentations in their entirety and take notes. However, watching the presentation is a supplement to reading the text and not a replacement for it. This is Chapter 4D, Mens Rea, Concurrence, Ignorance, and Mistake. The reason I say 4D is because Chapter 4 has been divided into 4 parts, 4A, 4B, 4C, and 4D. It is assumed that before you watch this video and take notes that you've already watched Chapters 4A, B, and C. The last few subjects of Chapter 4 include ignorance of the law and ignorance of the facts. You may have heard the phrase, ignorance of the law is no excuse. It's probably been said many times on police television shows. What that basically means is you can't say, I didn't know the law said I couldn't kill my wife. Because regardless of whether you knew it or not, you're responsible to know what the law is. You can't claim ignorance of the law. The problem with this concept is that sometimes people who are morally innocent, in other words, they had no idea they were doing something wrong, could still be liable. Well, obviously, if you killed your wife, you knew you did something wrong. But, for instance, what if someone says, I didn't know the speed limit here was 30, I thought it was 40. Well, he's accountable for the speed limit even if he didn't know it. And so here, he may be morally innocent. He may have no intent whatsoever to violate the law, but he is merely ignorant of the law. Ignorance, however, is no excuse, and he can still be found guilty of violating the law even if he didn't know the law, because everyone is presumed to know the law. And if you think about it, if ignorance of the law was an excuse, then everyone would just remain ignorant. Everyone could go into court and say, well, I didn't know what the law said, and they would be found not guilty. That, of course, is an unacceptable conclusion of the matter in a civilized society, and so there's really no choice but to hold people accountable for the law, even if they don't actually know it. Ignorance of the law is different than mistake of fact. So let's explain what we mean by that. The law is one thing, facts are another. Let's say, for instance, that there's a loud cat in your backyard. He's been meowing and screaming loudly for hours. He's keeping you up. And you're so tired you won't be able to function at work. You finally get so tired of it that you hear the cat in the back and you point your gun into the darkness and shoot in the direction that you heard. But it turns out you killed a homeless person. Are you guilty? First of all, are you guilty of murder? Well, did you intentionally or knowingly kill a person? No, you didn't. So you're probably not guilty of murder. You made a decision based on what you knew. You thought it was a cat. Now, was it a smart decision to shoot into the darkness, not knowing for sure it was a cat? Of course not. It was an awful decision. And yet you didn't know that you were shooting a person. So your criminal liability depends on not the fact that there was a homeless person there. No, it depends on what you believe the facts to be. In this case, you believed that there was a cat there. So you could be charged with cruelty to animals for killing the cat. You could be charged with reckless discharge of a firearm. Are you liable for the death of the person? Well, you still can be liable for the death of the homeless person. It's just that you did not intentionally kill him. It wasn't your conscious objective. You didn't knowingly kill him. You didn't know that a person would die as a result of your behavior. What about reckless? Were you aware of the circumstances that there was a person there and you disregarded it? Probably not. What about negligence? Were you not aware, but you should have been aware? And I think we got you there. I think that even if you didn't know there was a homeless person outside, that you should have known. You should not have shot your gun into the darkness. And that was a gross deviation. That failure to perceive there was a homeless person there was a gross deviation from the standard of care that a normal, reasonable person would exercise. So in these circumstances, assuming the DA believes your story, you could still be charged with criminally negligent homicide of the homeless person. Mistake of fact matters when it negates the mens rea required. So here, because you were mistaken about the fact that there was a homeless person there, you could not have intended to kill the homeless person if you didn't know the homeless person is there. Therefore, you have no mens rea to commit murder. No, you could not intentionally or knowingly kill a person if you didn't know they were there. However, you could recklessly or negligently kill the person, and so you will still be held accountable for either reckless manslaughter or negligent homicide. You're still liable for the facts as you perceived them. So if you thought it was only a cat, you could be held accountable for cruelty to animals, possibly. And the facts as you perceived them was it was too dark to know exactly what was out there, and you shot into the darkness. Should you have known what was out there before you shot? Absolutely. And so the facts as you knew them were it was dark outside and you shot into the darkness not knowing what was there. That sounds like negligence. You didn't know, but you should have known. In a more common situation, what about an underage person trying to buy alcohol? Let's assume that the law says it's illegal to intentionally sell alcohol to a person under 21. So intentionally, it has to be your conscious objective to sell to a person under 21. An 18-year-old comes in to the liquor store that you're working in, or perhaps to the restaurant where you're a waitress, and the 18-year-old has a false ID that says she's 21. That ID looks valid. So you sell her alcohol. Are you guilty? Well, if it looks valid, that means you thought she was at least 21. So you're not guilty because the law says you have to intentionally sell alcohol. You had a mistake of fact. You didn't know that she was only 18, but the mens rea required that you intentionally sell it to a person under 21, so you're not guilty. Let's change the facts a little bit. The law in this case says it's illegal to negligently sell alcohol to a person under 21. Here, the 18-year-old comes in. She's got a false ID, but this time, it looks false. It looks like a fake ID. Any reasonable person could tell that's a fake ID. Were you negligent? In this case, when you sell her alcohol, you are guilty. Why? Because negligence says you didn't know. Well, you didn't know for sure that she was under 21, but you should have known because the ID looked false. You should have known. So if the law says it's illegal to negligently sell alcohol to a person under 21, you are guilty because her ID looked fake. You should have known. Change the facts again. Now the law says it's illegal to sell alcohol to a person under 21. It doesn't give a mens rea. Here, the 18-year-old, she still has a false ID saying she's 21, and this is a really good ID. It looks exactly like a valid license. So you sell her alcohol because her ID looks good, but she's only 18. In this case, this is a strict liability law. It's illegal to sell alcohol to a person under 21. It doesn't say anything about intentionally, knowingly, recklessly, or negligently. You do it, you're guilty. And so under strict liability, you would be guilty even if you had no idea that the ID was false. So in each case, you had a mistake of fact. She was 18, but you thought she was 21. In each case, depending on the way the law is worded, the mens rea determines whether or not you are guilty or not. And that is one of the reasons why lawyers argue so much for every single word of the law, because it may make a difference as to whether their client is guilty or not. Is it a right to remain ignorant? Well, ignorance of the law is no excuse. So you shouldn't remain ignorant, but in this comic from Calvin and Hobbes, I don't know, but I refuse to find out. He's making a choice to remain ignorant, and that's going to cost him in the long run. And that's the end of Chapter 4D and the end of the entire Chapter 4. Thanks for joining us. At this point, you should be studying the entirety of your notes for Chapter 3 and 4 to prepare for your next exam. Have a great day.